So these are the two issues between the remaining parties. Did the defendant's structure that they're building on their property, and I'll show you photos of that in just a moment, without neighbor owner approval, comply with the architectural regulations? And secondly, does the structure substantially interfere with plaintiff's use and enjoyment of his property? So the facts are straightforward. In July of last year, the Thomases began constructing, and it's been called a number of things, a gazebo, a patio. It's a large structure, and I'll show you photos next. But they began constructing this right next to the property line, next to Mr. Backus's property. And this is the basic issue in the case. The architectural regulations require written approval from the neighboring property owner if the proposed construction will affect the privacy and/or view of the adjoining residence. So this was the view. This is from the Thomas's property. Mr. Backus and Dr. Thomas, their properties adjoin each other. This fence separates the properties. This is looking at the Backus property from the Thomas property. And this is the way it existed until the trees were cut down and this was constructed. This is the view from Mr. Backus's property looking toward the Thomas property. Right here is the top of the fence line. And this is an incomplete structure. After the lawsuit was filed, we had requested injunctive relief, and the Thomases just stopped constructing this structure. So it has remained largely in this condition for the last year. These are two pictures from Mr. Backus's home. The one on the left is what he sees from the main living area. You can see this massive structure pretty much encompasses the windows. The one on the right is another photo looking out from the windows inside his home. This is an aerial view. On the left is the Thomas property. On the right is the Backus property. And you can see the red rectangle is the structure that is at issue in this lawsuit. And then the final slide that we have is this is a rendering that we were provided, which apparently is what this structure is supposed to look like when it's completed, with one TV and a fireplace. It looks like another television over here to the left. So that is basically what this case is about. The issue that came up a few weeks ago is Mr. Grisham, on behalf of the HOA, got the board of directors to pass an amendment and delete that one sentence that I showed the court that's at issue in this case that requires neighbor written approval if you're going to construct something on your property that affects their view or privacy. 3 weeks ago, that was deleted. We had no notice any of that was going to happen. I have probably no less than a dozen objections to that. They fall into a couple of categories. One is admissibility, because being within 30 days of trial. The second category is the validity of the changing the amendment or passing the amendment, deleting that sentence out of the regulations. It doesn't follow the property code for numerous reasons, and it's invalid. It was filed with the real property records, and it's on file right now. And when I saw Mr. Grisham's timesheets, The reference is that they were seeking to, quote, moot the plaintiff's lawsuit, close quote. And so the question becomes, because that was done within 30 days of trial, is any of that admissible? And basically, the removal of that sentence from the regulations guts my client's lawsuit. No discovery was done. Discovery was cut off in July. This was filed with the real property records July the 23rd. It was filed after pleadings amendment deadline had passed, after the discovery deadline had passed, even after the exhibit list deadline had passed. So we have no witnesses designated to testify about this. In fact, this amendment is not even on anybody's exhibit list. So what the Thomases did was just a few hours on July the 23rd, after that was filed by the HOA in the real property records, they resubmitted their construction application to what is called the Environmental Control Committee. And it's similar to an architectural control committee, but they just have a different name. So they resubmitted it, even though it had been approved a couple of years ago, and it was reapproved after this invalid amendment had been filed in the real property records. So the question before the court is, and this is in my motion in limine, is anyone going to be allowed to bring that up to the jury?
All right, let me hear from Mr. Downing.
Yeah, sure. We've thought about that. One part of their motion in limine further, since we've received the motion, had our conference, and we're not objecting to that portion of the motion in limine being granted. We're ready to go forward on the prior approval and all the facts relating to that as it occurred, which is part of our other pretrial motions that I'll argue to you in later this hearing.
Okay, so Mr. Joseph, it sounds like the jury's not going to be hearing about that.
That
Is what
Your Honor, thank you.
Okay.
There was, while we're on there was one other issue on my motion in limine, if you want to take that up now so we can put that to rest.
Okay, I have it in front of me.
Okay, it was so, and Eric, you can correct me if I misspeak, but my understanding is Eric has agreed to number 1, number 3, and number 4, and only number 2 remains at issue.
And that's correct, yes.
Okay, so let's talk about number 2.
So number 2 is not mentioning to the jury any pretrial rulings on motions, including the motion for summary judgment that was granted on behalf of the HOA.
Okay, I guess let me hear from Mr. Dowdy as to why he thinks that would be appropriate for the jury to hear about those things.
So the only pretrial ruling that we had in mind here was Judge Meacham's order that granted the summary judgment filed by the Courtyard Homeowners Association. I think that order was entered on the 23rd of July. That's the only one that we think the jury ought to be apprised of, and so there's no other rulings. When it comes to that, we filed a trial brief in support of asking for a jury instruction relating to that order. Basically asking for an instruction that explains that the claims that Mr. Backus filed and asserted against the HOA, basically the ECC of the HOA, have been dismissed, not giving any, putting any language that gives weight to that dismissal or of any kind of language of that nature. And so it's just that one ruling, and it would be an instruction that would make its way into the charge if the court accepted that request. So other than that, it's not a plan to reference that order during testimony. It's just a jury instruction is what I was thinking there.
If with that in mind, Your Honor, I would just ask that the court grant that, and when we do our charge conference, then we can discuss that instruction.
Okay, well, let me ask you this. So typically speaking, we give the jury the questions that they are being called upon to determine factual disputes. The parties to this case are now Mr. Bacchus as trustee of the trust versus Dr. Thomas and Miss Thomas. There are no claims that the jury is going to determine about the HOA. So why would the court need to instruct this jury one way or the other about that?
So, Your Honor, I think as the jury listens to all of the evidence relating that's put on by the parties, it's inevitably the ECC, the HOA's name is going to be wrapped up in all of this. And I think the jury is going to be sitting there asking themselves, what is their involvement? What is their liability? Why are they not a party to the suit in all of this? I think even some of the evidence refers to the fact that the lawsuit was filed against both the HOA and my clients. And so I think the jury is going to be apprised of what their involvement was and be asking that question, why aren't they at trial? And this is an instruction that, as if granted, would not place any weight on the decision, would not provide any kind of opinion on the decision. It would just be providing the jury notice of why the HOA is no longer at the table.
Okay. All right. Well, it sounded like Mr. Joseph might be able to work with you, Mr. Dowdy, to put together. I guess what you're both telling me is the jury is going to be wondering, why isn't the HOA here? They're going to hear evidence about the HOA and the committee and see various documents as it relates to them. So y'all, what I would propose is that you to put your heads together and work out a proposed instruction that can be agreed upon, and we can add that to the charge. Is that something that y'all can get started on maybe this evening or tomorrow at the beginning of the trial?
Yes, Your Honor. I'll be glad to try and do that.
Yes.
Okay, great.
I just want to make sure I'm taking Eric at his word that he's not going to put on evidence or testimony about the summary judgment being granted, or the HOA had previously been a party in the case, and that's why I have it in the motion in limine. And I would, based upon his representation to the court, ask that the court grant number 2.
Okay. All right, I'm going to do so, and I will ask counsel to come up with a proposed instruction that you think accomplishes the limited purpose of educating the jury as to questions that they may have. But a summary judgment ruling granted by the court was obviously, a legal matter that is not going to be put in front of the jury. So I do not expect there to be evidence, testimony, argument about that topic. So
Right.
I will grant number 2.
Thank you, Your Honor. And that takes care of the plaintiff's motion in limine.
Okay. And Mr. Dowdy, what about defendant's motion in limine? Have y'all reached some agreements on any of these items?
I believe that we did. We have 6 total, and I think that the only, and correct me if I'm wrong, Richard, but I think that number 6 was one that the plaintiff had issue with.
5 and 6.
5.
I agreed to 1 through 4.
Okay, I'll mark 1 through 4 as agreed. And let's talk about number 5.
So number 5 goes towards, there's other pretrial motions that were filed, and one of them, well, let me back up, Your Honor. So the plaintiff designated a realtor as his expert on diminution of his land. As Julie Weidelick. There was a motion to strike that was filed by the HOA and heard by Judge Thomas, I think back in June or early July. And we joined that motion. An order was entered on that basically said Ms. Weidelick cannot testify to things relating to the governance or application interpretation of the ECC guidelines, but that she can try to or she can testify to the diminution and market value of Mr. Backus's home. And then I think the other layer was the potential buyer pool for his home, what that is, or that it's smaller because of this patio. And so that entered that judgment, I'm sorry, Judge Thomas entered her order. And then I think less than 2 days later, a new disclosures were issued by Mr. Backus's counsel. This was after discovery closed. This was after the order, as I just mentioned. And so there were some opinions that were added for Ms. Weidelick. They basically changed the format of the damage opinion from being 5 to 10% diminution in market value to at least 5 to 10%. So that's a big change. There also was addition of something that had not been disclosed before, which was a days on market analysis. And even though Judge Thomas's order said, no, Ms. Weidelick can't testify to things related to the deed restrictions, the ECC guidelines, the impact on privacy, that subject matter still made its way into this disclosure that was issued after Judge Thomas's order was entered. So that's what we're why we've arguing that motion in limine, is we assert those kind of opinions should not be heard by the jury. And then also Mr. Backus himself, I believe under the property owner rule, provided or listed himself as an expert for diminution of value. But my recollection is I have not seen a report from him. I have not seen a analysis or an opinion from him.
Your Honor, my response, would you like to see Judge Thomas's order? Would that be helpful to the court?
Yes,
Okay,
thank you.
sure. Are you able to see it?
Yes, I am.
Okay.
Okay. And then there's a second page, I presume.
There is, Your Honor. This is what she's allowed to testify about. These 5 topics.
Okay.
So my response is, number one, she didn't change any opinions. What he said was the disclosure went from 5 to 10% to at least 5 to 10%. We're going to offer her report. It says 5 to 10%. She's not going to be down here testifying. She's actually on a 10-year anniversary trip. So we're going to read portions from her deposition, and she won't be down testifying about at least 5 to 10%. So that should take care of that part. The second thing he said was days on market. It's not a new opinion. She just simply said the house could linger on the market longer because of the structure that's being built next door. The and I can provide the court the cases, but the cases are clear that an expert may refine their opinions through the time of trial. All we have to do is give them the general subject matter upon which the expert's going to testify. That's what Rule 195 says. We've done that. Both defendant sides deposed her for almost 3 hours. She produced a report. So the testimony that's going to be offered is from her deposition that they have, and from a report that she will not be down here testifying live and give any new opinions. So what she has said already, are her opinions. I don't know if that helps the court, but that's the response.
Okay.
And then as to Mr. Backus, he doesn't have to provide an expert report. Rule 193.6 is clear that parties are exempt and do not have to be designated. Parties do not even have to be designated as witnesses, much less experts. So the only way he could exclude Mr. Backus from testifying about that is 193.6. It explicitly says named parties are exempt. I can read the portion to the court from the rules of procedure if you want me to.
I'm familiar. That's okay.
Okay. So that's my response, Your Honor.
Okay. You can bring down the screen share. And anything else on that, Mr. Doughty?
No, Your Honor. I think now knowing and having confirmation that Ms. Weidelich's not going to testify and it's just limited to her report, my understanding is that report that they will attempt to admit is from May 6th, meaning it was not the report that I'm talking about that was disclosed, 30 days out from trial. So I think that alleviates our concern on our side. So no further response.
Okay. So do we think we have an agreement and understanding on item number 5 based on what Mr. Joseph has said?
Yes, Your Honor, I'd say so, as long as there's not a surprise calling of Miss Weidelich while she's on her 10-year anniversary.
Okay. He's gonna read her deposition is what it sounds like.
That's what we're gonna do.
Okay. Fair enough. And that's not a video, that's something we're gonna read it to the jury?
Well, Your Honor, we're gonna have to, unfortunately, do it the old-fashioned way. It would take, I was told, 10 days to get the video, and so we're just gonna do question and answer, reading it the old-fashioned way, if that's okay.
Okay, that works.
It won't take any more time than if she was testifying, I don't think.
Sure. All right, then item number 6 is, let's see. All right, why don't, let's move to number 6.
So, Your Honor, the basis of this is the order that Judge Meacham entered. That claim from Mr. Backus has been dismissed. That for him to come into trial and then mention any of those things would be prejudicial, I think, to my clients. It's not, as you said, or as we've talked about earlier, they're not deciding an issue as it relates to the claims between Mr. Backus and the HOA because they're no longer parties, so it's also not relevant. Yeah.
Okay, Mr. Joseph?
Well, I'm not, frankly, I'm a little unclear as to exactly what this means. What the case that we're going to try to the jury is that the Thomases should have gotten written approval from my client to build that structure because it obviously affects the view and his privacy. That approval should never have been granted. One of the issues we had with the HOA was they never came out to even look at it or investigate. So we're not going to submit anything to the jury about whether or not the approval was invalid, but we're certainly going to claim that it never should have been approved without Mr. Backus's written approval, that was a precondition and nobody ever got that. So that's I'm not sure how that applies to number 6, because number 6 is a little unclear, but that's our case, that they
Okay.
should have never been given approval because they didn't get his written approval.
Okay. I think you can get into that without getting into these other things about the application being invalid or ineffective or unenforceable. Mr. Doughty, it sounded like what Mr. Joseph plans to do is limited to the approval of the landowner, not the HOA. Is that something that can we thread the needle on this?
It's going to be hard, I think, Your Honor. I mean, this is just to let you know, like, this is part of the biggest pretrial motion that we have not argued yet, but that we need to have you address. And so if the plaintiff is going to say, well, he thinks it's not valid because my clients didn't get approval, that's one thing. But I'm just not quite,
That's what we're claiming, what you just said. That's the lawsuit. I mean,
I think, how can you say that in front of the jury, Your Honor, without arguing that the actual ECC approval is invalid without authorization?
Because what the HOA did or didn't do isn't an issue that's contested as a part of this lawsuit anymore.
Yeah. This is the other thing, Your Honor, that I think is important. The standard of reasonableness for the HOA is different from the Thomases. So under the property code, the standard is higher for an HOA. A claimant has to show arbitrary, capricious, or discriminatory. For the Thomases, it's just ordinary care. So that's what the main reason I think they filed the summary judgment was this higher standard of care that applies to the HOA. The other thing is, in the motion for summary judgment, they had argued that our testifying expert, Ms. Wadelick, that her testimony was inadmissible. At that point, when the summary judgment had been filed and heard, Judge Thomas had not ruled on this motion to strike and motion to exclude a report, which Judge Thomas subsequently allowed her to testify about the valuation. So that was not before the court when the summary judgment was argued. The third thing is, the summary judgment order simply says the motions are granted. It doesn't say why. And so I think it's unfair for the defendants to try and extrapolate rulings or limit our proof that we can offer to the jury based upon their interpretation of an order that doesn't say why the court granted it. So for those reasons, I think this should be denied.
Okay.
Your Honor, sorry to interrupt. I just think that the pretrial, the 166 motion, I know that I'm asking you to put this motion in limine issue aside, but I think hearing the arguments, the full arguments from both sides for that will potentially help the court make a decision on this ruling on the motion in limine, because it's all the same subject matter. It's all, what does this order mean, and what can the plaintiff come into trial saying that is appropriate, given this ruling, given what the factual issues are that would be put in front of the jury. So,
Okay.
Yeah.
You want to table it?
Yes, I think it's more appropriate to table it, and we just shift this. This is the biggest decision, I think, for the court today, is these Rule 166 motions. So I'll go ahead and start, Your Honor. So we filed these after Judge Meacham signed her order dismissing all of the claims that the plaintiff brought against the Courtyard Homeowners Association. So just going back to the pleadings in the case, if you look at the live pleadings for the plaintiff, in each case, whether the original and then now I think the first amended, which is the live, he's asserted breach of contract, negligence, nuisance, and then deck actions against both parties. Basically, identical claims are being made, maybe a little bit of nuance when it comes to the nuisance part, but the gist, the principal issue in this case, as maybe you've already started to gather, is that the ECC gave an approval that the plaintiff doesn't think should have been issued. And the biggest reason for that, as argued by the plaintiff against both the HOA and my clients, is that his permission should have been sought. He should have been asked to sign off on this, or his feedback should have been sought. And so because it wasn't, and the approval was provided back in 2024 and then again in 2025, he's asserting breach of the guidelines, breach of the declaratory instruments, and then negligence relating to the issuance of that approval. And now there's a nuisance because of the patio that basically stems from the approval occurring because we have the construction of the patio. And then the deck actions that he sought were to have that approval declared ineffectual, invalid, without legal effect. And so if you look to the live pleading, he doesn't designate which of these claims are being pled against specific defendants. It's just defendants each time, meaning all three, the HOA and then my two clients. And so Courtyard filed a MSJ, combined MSJ, earlier this summer. Judge Meacham granted it July 23rd. It dismissed all of the claims that were asserted by the plaintiff against the HOA. And in the combined MSJ filed by the Courtyard, they argued that Mr. Backus couldn't rebut the presumption of reasonableness by the ECC. He couldn't provide evidence that the ECC acted in an arbitrary or capricious manner, which, as you may know, that's necessary to overturn the discretionary exercise of authority by an HOA's committees. The Courtyard also cited evidence and argued that my client's patio did not impact the view or privacy within the plain meaning of the guidelines, as those terms were used in the guidelines. They offered interpretations and arguments as to how the court should construe those terms. And they also cited to Mr. Backus's testimony, the plaintiff's testimony, where he testified he did not think his view into my client's backyard should be protected. And so needless to say, they addressed the interpretation of those words. They address the breach of contract that is basically saying, hey, this is how Mr. Backus thinks these terms should be interpreted. Because the permission was not sought, it's invalid. It all goes back to this permission and interpretation of these terms of view and privacy. And they made these arguments in their MSJ. And additionally, they also pointed to case law regarding the nuisance claim and argued it should be dismissed because Mr. Backus's claims are solely aesthetic and emotional. And they cited the case law that showed that a nuisance claim should be dismissed or isn't supported by such evidence. And so as to Mr. Joseph's comment about Judge Meacham's order not having any kind of findings or any kind of language that we should be able to rely on, well, of course, judges don't put any kind of findings in summary judgment orders, is my understanding. But the case law and authority that we cited to says, in other words, if summary judgment is proper, there are no facts to find, and the legal conclusions have already been stated in the motion and the response. And so I take that to mean and contend, Your Honor, that the arguments made by the HOA Courtyard in their motion as it relates to how to construe these guidelines and what the words view and privacy mean were adopted by the court and accepted by the court, hence them dismissing Mr. Backus's claims, all of them, including, again, breach of contract and his request for a declaratory judgment that the approval their ECC provided was invalid, was without legal effect. So we're here under 166, which allows for judges, for courts during pretrial conferences to enter directed verdicts when there's no facts to find and when there's no other no other verdict can be entered. And we contend it's the same here. We're not asking or putting on any evidence. We don't think that there's any factual issues that we're asking you to look at and decide during this hearing. We're asking you to dismiss all of these claims that have been pled by Mr. Backus against my two clients. Again, the claims he's pursued against my two clients all center on this approval. He alleges that they breached the guidelines by not getting his permission, not getting his consent before constructing their patio. So some other points I wanted to highlight, Your Honor, and I'll try to wrap things up, but the reality is the documents, and I don't think anyone can argue against this, is that the ECC is the only party, or not party, but the only committee of the HOA, of the Courtyard HOA, that can issue these kind of approvals. And Mr. Backus challenged that approval. He had his chance to assert claims against the Courtyard to have that approval reversed, and he failed. And so we contend there's no way for the approval to be now declared invalid or without legal effect. The only obvious or the only possible answer is to declare that the approval has legal effect, that it is enforceable. And that's what our 166 motion that we're arguing right now is for, is we want the court to grant the counterclaim for declaratory judgment that the Thomases have put forward in their counterclaim, which is asking that that approval be declared valid, enforceable, in effect. If that happens, if the judge grants, if you grant that request, Judge, then those breach of contract claims that were also asserted against the Courtyard, that are also asserted against my two clients, should similarly be dismissed. So another reason I think that our request here should be granted is if this issue of whether my clients complied with the ECC guidelines is put to the jury, and the jury answers no, they failed to comply, or I'm sorry, yes, they failed to comply, then we're going to have conflicting rulings. We're going to have a situation where an approval is said to be valid as it relates to the Courtyard, but it's not valid because my clients didn't obtain some permission. And so I don't think that's tenable. That also would create an issue with, I think it's unworkable precedent when it comes to these kind of issues, where if a homeowner who's aggrieved by an approval that relates to them that their neighbor received or another homeowner in their neighborhood received, they file suit and then claims are dismissed against the HOA. They just get to keep going and then keep pursuing claims against the individual applicants. I don't think that's workable. It makes the approval process pointless. It makes the litigation over the same or similar claims that are asserted against the HOA and its subcommittees meaningless. So I think there's plenty of reasons for the court to grant this 166. I guess one quick note, a couple other notes, I apologize, Your Honor, but Mr. Joseph, you mentioned this a moment ago. Yes, the standard is different. The standard applicable to the HOA whenever a aggrieved homeowner is trying to overturn an approval is different than the ordinary care, but in plaintiff's own response to our 166 motion, he admits that the standard is actually higher as it relates to the HOA than it is to my clients. So I find that interesting. As to other arguments that have been made by plaintiff in their response, they seem to center on whether we're asking the court to make a factual determination or take away some kind of determination from the jury. I disagree here. This is all based on a legal ruling, legal claims that are being made. There is no factual dispute as to this now. That the approval from the HOA cannot be overturned. It can't. Those claims are gone, as we've acknowledged during this hearing. And so my clients ought to be able to rely on that approval and in turn have their declaratory judgment aimed at the plaintiff granted. So the last bit is, and I can understand if the judge says, if the court says, well, there is still a nuisance claim to be had here, or that is a factual determination for the jury. I would respectfully disagree, just because of the case law that's been cited by the courtyard. That nuisance can't be based on feelings or reactions to a change in view, which is basically what we have here from Mr. Backus. So to sum it all up, Your Honor, we're asking the court to enter pretrial directed verdicts under Rule 166. I think it's 166G is the exact section on legal issues, specifically declaratory judgment in favor of my clients that the approval was valid. And if that is granted, then for the breach of contract and negligence and nuisance claims to be dismissed. Thank you, Your Honor.
Okay, Mr. Joseph.
My response, Your Honor. First of all, this is an attempt to circumvent the deadlines in the agreed scheduling order. The agreed scheduling order required all dispositive motions to be filed by June the 1st and have hearings conducted by July the 13th. The Thomas defendants did not file a motion for summary judgment. If they felt so strongly about their position, they should have done so. They didn't. And as a result, they violate Mr. Backus's due process, because in a motion for summary judgment, the non-movement gets 21 days to respond, which we don't have here. He filed this 11 days before trial. You have to wait 35 days for a hearing. He hasn't complied with that. And a directed verdict is the equivalent of a no evidence motion for summary judgment. And the requirements for a no evidence summary judgment are that you have to list each element of a cause of action you claim that the plaintiff doesn't have any evidence. This motion is like 2 pages long. It doesn't list the elements that they claim we don't have any evidence. It wasn't filed according to the deadlines in the scheduling order, and it certainly wouldn't comply as a motion for summary judgment under Rule 166A. And yet that's what they're asking the court to do, grant them a summary judgment, and it's inappropriate. Secondly, it violates Rule 4.1 of the local rules that says that motions other than a motion for continuance cannot be heard the week before trial. And essentially, they're asking you to grant a summary judgment the day before trial is supposed to start. Thirdly, the legal standards and factual issues for the Thomases are different from HOA. As I mentioned earlier, Texas Property Code Section 202.004A says that the standard to be applied to an HOA is the exercise of discretionary authority being arbitrary, capricious, or discriminatory. That doesn't apply to the Thomases. That is a higher standard. It's a lower standard that we have to meet in order to get liability on the Thomases through negligence or nuisance. Secondly, the primary issue in this case, that being the architectural regulation that says that the Thomases had to get written approval from the neighboring property owner if the project would affect the privacy or view of Mr. Backus, that applies to the Thomases. It doesn't apply to the HOA. Those are architectural guidelines that a homeowner has to comply with, not that an HOA has to comply with. In other words, it's basically a condition precedent to submitting the application. They have to get the written approval from the neighbor. They didn't do that. They just started building this monstrosity next to his property. Finally, we obviously vehemently disagree with the granting of the summary judgment. We believe there are numerous fact issues for a jury to decide. There's fact issue as to whether or not Mr. Backus's view is affected. In fact, the defendant's own experts, appraisal experts, admitted the view was affected. There's a question as to whether or not this invades Mr. Backus's privacy. There's the televisions are going to be installed. That's an issue with privacy. There's a question about diminution of market value of its property. There's a question about damages for invasion of privacy. There's numerous fact issues for a jury to decide. And we believe that for the court to summarily just take that away right before trial is certainly unfair, would be inappropriate, and we would ask that the court deny this motion.
Your Honor, if I may respond briefly. So this assertion that my clients didn't get approval, and that's the reason why the approval was invalid. They already made that argument in their motion for in the response to the motion for summary judgment that was filed by the courtyard. That was already addressed. The court disagreed. Otherwise, if the court had potentially said, okay, yes, we agree with your interpretation, Mr. Backus's consent was required by, it should have been obtained by someone, either the ECC or my clients, then I think we'd be sitting here having different conversations. The HOA would potentially still be in this case, but they're not. They already made that argument and they lost. And so there's already been, in effect, a ruling made on this, Your Honor, I think, is that because the ECC is the only party that can grant this approval, it's the party that heard the declaration, the guidelines and the declarations for this neighborhood, it's the party that is charged with implementing and enforcing the guidelines. And so there is, they've already made these arguments and lost. I don't see any other logical result, any other ruling that can occur as a matter of law, other than for the claim specifically saying, hey, you, the Thomases, had to get my approval. Those are gone. Those were asserted against the HOA, and the court disagreed. If they want to take that up on appeal, they get to do that. But I don't think that my clients are asking, or they're asking for a lot here. They're asking for the claims that were asserted, which were the same against both parties. If you look at the pleadings, be treated the same, which is if neither of them had to give approval because of the interpretation of view and privacy, then that's the case. Then those kind of arguments should not be brought forward during this trial. It should just mainly be on, if there's a factual issue, I guess a nuisance that could potentially remain, but that's it, and an attorney's fees. So again, we cited to just a couple other quick notes. Like when I was looking up 166, I hear Mr. Joseph's argument about summary judgment and how we didn't file a motion, but Rule 66 allows and gives the court authority to make rulings like this. They're allowed to assist in the disposition of the case without undue expense or burden to the parties. The prior version of this 166 rule before 1990 did not authorize the trial court to determine the merits of an issue, but then it was amended. And so the case law we found and we put into our motion shows that you do have the authority to enter this kind of a ruling. And again, it's deciding a legal issue, not a factual issue. So again, Your Honor, we're asking these claims be dismissed, but also asking for our counterclaim, which is a declaratory judgment that the approval was valid, it's in effect, and it was authorized, that also be granted, Your Honor.
Okay, just give me a moment. Okay, having reviewed the motion and having heard from both sides, that I will deny the 166G motion. What is next as far as pre-trials?
We have exhibits. We've agreed on a lot of that as well, but there's a few things remaining.
Why don't we pre-admit all of the exhibits that are agreed to for the record? And then I'll probably just ask that anything that's not pre-admitted that you offer it at the time.
Okay.
Do you identify those by number for the record, Mr. Joseph?
Sure. I have agreed to, from the Thomas's exhibit list, numbers 1 through 37. It's my understanding that number 38, 40, and 41 were withdrawn.
Okay, and you're referring to defendants exhibits?
Yes, Your Honor.
Okay, Mr. Doughty, are those others withdrawn?
You said 38, 30. Sorry, can you repeat that again, please, Mr.?
Sure. Eric, my notes say 38, 40, and 41 were withdrawn.
That's correct. Yeah.
Okay. And what about plaintiff's exhibits, Mr. Joseph? What are we pre-admitting?
Eric, you tell me if I read this wrong, but I think my notes are correct. My understanding is the following exhibits were agreed to, 1 through 4, 7 and 8, 11 through 20, 23 through 32, 34 through 81, and I have a question for the court, Your Honor. My understanding is that exhibits that go to the jury and exhibits that are exclusively for the court both have to be uploaded. And so plaintiff's exhibits 90 through 108, most of which are discovery responses, are for the court only, and they related to this amendment issue. So
Okay,
I'm offering those for the court only, 90 through 108.
okay, what the court reporter will have you do is those will be marked as court exhibits. That notes for the record that anything labeled a court exhibit is not permitted to go into the jury room. Only P and D exhibits that are admitted go to the jury room. Court exhibits will be a part of the file and a part of the record of the case, but only will be for my view.
Okay, I don't know if I should ask the court reporter or the court, but should I designate them differently? I've designated them with a P, but I can designate them with a C. Is P okay?
CO1. Yeah, and just start at 1 and go through, 10 or whatever it is.
Okay,
8,
I will, we will
18.
redo those and do I need to offer them?
Yes.
Okay,
Are,
well
and
then,
are those agreed to, Mr. Doughty?
And so, Your Honor, and Mr. Joseph, my notes said it wasn't 90 through, well, that's part of it. I'm sorry, 90 through 108, but I thought it was 82, 83, 84. And then I thought it jumped up to 90 after that. So 82, 83, those are the casita, from 2021 or whenever that was.
okay. So maybe you didn't agree to 82 through 89.
Right. Well, I thought 82 basically going all the way up was what you were referring to as the court.
Oh, no. Just so it's clear, Your Honor, 82 through 89 are jury exhibits, and then 90 through 108 are court exhibits. So
Okay, why don't we go back to the plaintiff's exhibits that we agree can be pre-admitted? I had 1 through 4, 7 and 8, 11 through 20, and then
Your
then
Honor, I think it's 10 through, starting at 10.
okay,
not
10
11.
through 20.
Yes, Your Honor.
And then what's the next?
23 through 32.
Okay. And then
And then-
34 through 81?
Yes, that's what I have.
Yes.
Okay. And Mr. Doughty, you agree that those plaintiff's exhibits may be pre-admitted by the court?
Yes, Your Honor.
Okay, those are pre-admitted as well as the defendant's exhibits that we discussed earlier, 1 through 37.
Okay. And just offer the rest of them during trial.
Yes.
Okay.
Anything that's not agreed to, you can offer during trial, and maybe there will be an objection and maybe they won't. We'll just take them as they are offered.
Okay.
But at any time during the trial, you can relabel the court exhibits, renumber them, and we can offer them on the record.
We will do that this afternoon, Your Honor.
Okay, perfect. Okay, that takes
Well-
care of at least pre-admitting some of the exhibits. And have y'all been able to confer as far as trying to streamline the scheduling of witnesses so that the presentation of the evidence runs smoothly for our jury?
We've talked about it. There is one witness that's been designated that had not been designated previously. I don't know if you want to just take that up when the witness is called or do it now.
Well, I guess it depends on whether there's going to be an objection to that.
There will be an objection.
Okay. So who is the late witness and why?
So, Your Honor, that I think he's referring to Justin Sims. So some backstory
Right.
is that is that correct, Mr. Joseph?
That's correct.
So the courtyard hired an appraisal company, Hornsby and Company, to provide an appraisal report for Mr. Backus's property. That report was provided pursuant to the deadlines and the scheduling order. The report itself was signed by Chris and Paul Hornsby, their father and son appraiser duo, but also another appraiser in their office, Justin Sims, another licensed appraiser. Whenever that appraisal report was produced, back whenever the deadlines and disclosure requirements were occurring, his signature was present. Mr. Sims' signature was present. The plaintiff only chose to depose Mr. Chris and Paul Hornsby, the father-son duo. During at least one of their depositions, it was disclosed Mr. Sims' involvement, his authorship of the report itself. Our anticipation was, again, as I think someone noted, maybe you did, Your Honor, or Mr. Joseph did, that when we did our witness lists and our exhibit lists, it was actually before Judge Meacham granted the summary judgment from the HOA. And so at the time, our understanding or our thinking was that the HOA was still going to be a party, that Mr. Hornsby, or I'm sorry, one of the Mr. Hornsby's, Chris or Paul, would be appearing to testify. And so with the entry of that order, we've had to obviously pivot, as you can see. And so one thing that we've learned recently was that both of the Hornsbys are unavailable to testify next week, but that Mr. Sims is available. And so we served a amended witness list listing Mr. Sims to testify as it relates to the contents of his report. That was again provided pursuant to the DCO. Plaintiff had the chance to depose him, chose not to, instead chose to depose the other authors of the report. And so we had planned to bring him to testify to the report and the opinions therein.
Okay, Mr. Joseph?
My response, Your Honor, Mr. Sims was designated for the first time by any party today. He was never designated as an expert witness by the HOA, and that's why I didn't depose him. They designated Paul Hornsby, Chris Hornsby. I deposed both of them. I do not go and spend my client's money frivolously deposing everybody whose name is in a document produced in discovery. He wasn't designated as an expert by the HOA, never been designated as an expert by the Thomases. He's never even been designated as a person with knowledge of relevant facts by anybody until Mr. Dowdy designated him the day before trial. He's never been on a witness list until today, the day before trial. And the case law interpreting this issue states that under Rule 193.6, if a witness, fact or expert witness is not timely designated, they're automatically excluded. And as the court knows, the offering party has to show good cause, no unfair surprise, no unfair prejudice. One other thing that the case law mentions is, even if I had designated Mr. Sims as an expert or a person with knowledge of relevant facts, they don't get to rely on that and call him, because a party is entitled to rely on the opposing party's designation to know who they need to prepare for trial to cross-examine. And as I said, the first time he's been designated by anybody as a fact or expert witness is today. And obviously it's a surprise. Obviously we're prejudiced, and I don't think Mr. Dowdy has shown good cause, so I would ask that he be excluded.
All right, so Mr. Dowdy, when, if ever, did the Thomas defendants name Mr. Sims as an expert?
So we didn't name him as an expert in the disclosures. We did a cross designation in our disclosures to rely on the testimony of other experts designated by the other parties. We didn't mention him by name.
Well, Your Honor, the cross designation isn't effective either, because that presupposes someone else designated him so he could be cross designated. He was never designated by the HOA. He's never been designated by anybody as an expert or fact witness until this morning.
Your Honor, my response to that would be that counsel and plaintiff have known about Mr. Sims. His signature is evident. It's right underneath the Hornsby's 2 signatures in that appraisal report that they received timely, and that they could have requested the deposition of Mr. Sims, but they didn't. After they learned his involvement, after deposing Mr. and Mrs., or I'm sorry, the 2 Hornsby's that were designated by the courtyard HOA.
And Judge, that's an absurd interpretation. That's like saying, okay, if you have a medical malpractice case and one doctor can't testify, one of any other of the 20 doctors who appear in the medical reports can come testify in his place. I don't think that's what the rules intend. It's not fair. We're surprised. We're prejudiced. Good cause hadn't been shown. He should not be allowed to testify.
Okay, so knowing a person exists and knowing that they might be called as an expert are 2 different things. This is why disclosures exist, and this is why trial witnesses must be disclosed, persons with knowledge of relevant facts and or experts. So Mr. Sims is not going to be permitted to testify given the failure to disclose. I don't find good cause. I do think that it would amount to surprise. So any other pretrial motions that we need to take up?
None on behalf of the plaintiff, Your Honor.
Okay. Anything on the behalf of the individual defendants?
One moment, Your Honor. I'm just double checking my list. No, Your Honor.
Okay. All right, then let's talk a little bit about how voir dire is conducted in my courtroom. And I'm going to give you kind of the lay of the land as far as our scheduling and housekeeping items. Our voir dire panel will be reporting at 9 a.m. tomorrow morning. So they will be set up in the gallery, and you will do as you normally do and turn your chairs to face and direct your examination towards the panel. And I think you should have your jury list by now.
We do.
Okay, great.
That was most excellent to get them a few days earlier. That's a great way to do it, Your Honor.
All right, well, I'm sure Ms. Price at the district clerk would love to hear that feedback, but yes, it is helpful. You've had your list. I have not been contacted today by anyone saying they're sick or seeking to be excused, but I'm sure there may be one or two no-shows, but we will try to get started just as soon as we can, but it, in all likelihood, will be 10 or 15 minutes after the hour before we get everyone assembled. I will have to read through the litany of instructions required by the Supreme Court of Texas before I turn over the panel to counsel for examination. One thing I do need from you, I give a very neutral statement of the case. Generally, one sentence, many cases. This is a car wreck involving claims for personal injuries. You can speak offline and let me know if you come up with an agreed sentence I can give them. This is a nuisance case involving neighboring property dispute, or you tell me what would make the most sense. I introduce the parties, I introduce counsel and let you introduce your parties at your table, and then I guess I'll inquire. I'll consider how much time you would like to have with the panel, although I may or may not give you as much time as you'd like, but I'll let you tell me. I'll request input from you, Mr. Joseph. Do you have a request as it relates to the amount of time you examine the panel?
45 minutes or so.
All right. Mr. Downey?
I was thinking more like 30 minutes.
Okay. All right, what I'll do is I'll go ahead and I'll give each side 45 minutes. And if you use less, then great. I will say if both sides use 45 minutes, that may cause us to need a comfort break for some jurors who can't, sit still for that long, but we'll just do our best. My goal is to have the 12 jurors impaneled prior to the lunch break. That's my goal, and I will probably be able to accomplish that. But with a 2 or 3 day trial, I would not anticipate seating an alternate unless you tell me of a reason why you think I should.
Well, don't think it's necessary, Your Honor.
Okay.
Same.
Okay, good. So no alternate. We will, generally speaking, after you have both examined the panel, I'm going to ask for a list of anyone who thinks they want to be let go for an economic or a medical excuse. We will bring up all the challenges for cause first, and then we will talk with anyone who's seeking to be excused for medical or an economic reason. And that's kind of the way that goes. Then when we're done, I will ask you pretty immediately for your list of who you want to strike, and I will send everybody out, and then we'll bring in the jurors who are the subject of any challenge for cause one by one and speak with them privately if I think we need to. Sometimes there's people that I will excuse for cause just based on what I've heard and don't need to talk with them further. Oftentimes there's a need to speak with people outside the presence of the group. Anyway, we will start at 9. We all generally, once the trial gets going, we have a mid-morning recess and a mid-afternoon recess for our jurors, and the jurors get a lunch from around noon to 1:30 each day. I may need to take up some of your time during that hour and a half outside their presence if there's any evidentiary issues or any legal issues that we need to talk about without the jury there. I let them go at 5 every day. So if you call a witness at 4:30 and you don't get the witness off the stand by 5, just know that I'm not going to keep the jury late just because you want to get your witness done. They're spending time with us away from their jobs and families, and I think we need to be respectful and kind of keep things reasonable as far as
Absolutely.
letting them go at 5. So that is what I have for you. Let me turn it over and see if either of you have any questions, starting with counsel for the plaintiff.
I just had, not about that, Your Honor, I had one housekeeping question I forgot to ask you. The court exhibits, what box file do I put those in? Because I've already been asked to, I've been given a new file today to put everything in, and I've done that, but they want to put them in the wrong file.
I think Ms. Simon will create one for court exhibits now that we know we're going to need one.
Okay,
We don't always need one, but it sounds like this case needs one, so she'll create a new folder once we're done here, and you'll be able
okay,
to upload later this evening.
okay, great. Thank you so much. That's the only question I had, Your Honor.
Okay, great. And Mr. Dowdy, anything on behalf of the defendants?
No, Your Honor.
Okay. All right. There are 2 conference rooms contained within our courtroom complex. You should each stake a claim on one of those and feel free to utilize it through the trial. And I don't think I have anything else for you. Ms. Seeger is your point of contact should anything come up as far as questions or concerns. I think y'all are both familiar with the courtroom technology, so I anticipate that won't be an issue. So if this afternoon you want to email Ms. Seeger, if you want to discuss that neutral sentence about the case that I can tell the jury and send over the order restyling the case, Mr. Joseph will get that taken
Yes.
care of. And I think that takes care of it.
Okay. Eric, I'll give you a call when the Judge Mangum releases this, and we can talk about that sentence.
Okay.
Okay, fair enough. All right. Well, I appreciate your efforts to make this a smooth presentation of the evidence for the jurors. And so we have an announcement of 2 to 3 days. That's what we're working with. So what I will do, and I'll think about it this evening and I'll let you know tomorrow, I'm going to divide up the time so that the case is submitted to the jury, let's see, probably by lunchtime on Thursday would be my thought.
Okay. Can you tell us how much time we have?
Give me a second here. Let's see, we have a Tuesday start. Okay, so I'm thinking probably 5 hours per side. Now, that does not include voir dire. Voir dire is not on the clock for me. Voir dire is basically going to take most of the morning. And then, so we'll have really a half day of evidence Tuesday afternoon, a full day of evidence on Wednesday, and a few hours Thursday morning. I want to give your time announcement is supposed to include the jurors actually deliberating and returning the verdict. So let's start with that and we can see how it goes. I'm very conservative in estimating my time. So while I've allotted what basically is 5 hours per day, we actually do end up getting in more like 5 hours and 15 minutes, 5 hours and 20 minutes per day. So I'm kind of building in a cushion if something were to come up. But I think based on what the witness lists I've seen, I'm pretty confident that that will be a workable schedule.
It's workable for us, Your Honor.
Okay. Mr. Dowdy, you think that works for the defendants as well?
Yes, Your Honor, especially in light of a lot of our exhibits being pre-admitted.
Okay, fair enough. All right, great. Well, we will see you bright and early at 9 o'clock in courtroom 9D.
Thank you so much for your time, Your Honor. May we be excused?
Sure. Yes, y'all are all excused. Have a good evening. Thanks so much.
You too. Bye-bye.
All right. Bye.